Okay.
I also feel that she understands the range and nature of possible penalties that could be imposed upon her. We discussed what she believes to be a 25-year sentence if she's found guilty of the charge. And I also discussed with her, was there a possibility of a life sentence? We also discussed the adversarial nature of the legal system, the role of her attorneys, and the role of yourself, the judge, the role of the state attorney, and the role of, I think I've already said the jurors.
Nope.
Okay, I'm sorry, the jurors also. She had confidence in the jurors that had been selected. She trusts that you're going to be fair and impartial. We also discussed the facts of the case and her perception of what the allegation is. And in my opinion, of course I've read about this case prior to ever meeting with her, and she was, in my opinion, very consistent with regards to what's been reported in the newspapers and on television. And so I thanked her for her honesty, being forthright. I also feel, so because of that, I feel she has the ability to consult with a reasonable degree of rational understanding. And also very much related to that, if she chooses to take the stand, which she knows that that's her options to if she wants to testify, that she has the ability to testify relevantly and rationally with regards to the allegations. And I do think related to that also, she can handle cross-examination. And finally, I feel that she has the ability to manifest appropriate courtroom behavior.
I want to follow up with you on the penalty. So where did that 25 years come from?
That's what she said to me. That's what she told me, and I don't know. I did not clarify that with Mr. Trevino.
All I can say, Your Honor, is that she has been explained that if she is found guilty as charged, there are only two possible penalties: death, which the state has waived, or life in prison without the possibility of parole. She may be thinking of, sometimes we discussed the possibility of asking for lessers and how that might change the sentencing scheme, but never has 25 years been mentioned as the maximum penalty.
Okay, so it's your understanding, Mr. Trevino, please stand up. Please stand up.
Oh, I'm sorry.
In your conversations with her, in your communications with her, and I'm not trying to get into lawyer-client privilege, but I assume you have always told her, consistent with what I have always said, that the only possible sentence if she's convicted of murder in the first degree is life in prison without parole.
That's correct.
Okay, and you've never had any doubt that she understood that?
No, not until hearing this.
All right. Well, I think I'm going to ask you to go in the back and discuss that particular point further. Okay? Thank you. We'll be in recess till you're done.
Thank you, Your Honor.
Miss Mead, go in the back. I'll step down again. We can be at ease until they come back. They can take as much time as they need to.
All rise. Court is in recess. Still call the court.
Yes, we are. No.
belief was that that was a diagnosis at the time, but I don't have any medical records.
Okay. All right. Well, so specifically, Mr. Labruzzo, what you're asking is?
Judge, that there should be no mention of schizophrenia or any type of mental condition in opening statements, because quite candidly, that's not been.
Granted.
Got it.
Anything else?
And Judge, I guess that also is any type of low average IQ or intelligence level of the defendant, because we don't have any reports that indicate that to us.
Granted. Anything else? Okay. Are we ready to bring in the jury and swear the jury? Yes, no?
We are, Judge.
All right. You ready?
Yes, Your Honor.
Very good. Let's bring them in. They've only been waiting 2 hours and 10 minutes. Yes. You know what? I don't know. No, because I'm not.
Judge, could Mr. Trevino and I just approach briefly
Yeah.
about scheduling?
Yeah, and I'm wondering if I should even sign the form order appointing Dr. Poorman. I think not, because it's not indigent.
Correct.
Okay, all right, thank you. All right. Yes. I would like the jurors to be sworn. Is everybody ready for that?
Yes, Judge.
All right.
Stand up, raise your right hand, repeat after me. You do swear or affirm that you will well and truly try the issues between the state of Florida and the defendant whom you shall have in charge, and a true verdict rendered according to the law and the evidence, so help you God. Thank you.
You may be seated. You all have your pads? Okay, they're there. All right, just pass them out. We'll get to that part later. I want to apologize profusely for making you wait in the back. I know you were all here on time today. You all did your job exactly as you should. I apologize. Every once in a while, there's hurry up and wait, and this was a lot longer wait than we had anticipated, so thank you for being good sports, and we'll try to keep that as limited as possible. Okay? Ladies and gentlemen of the jury, you've been selected and sworn as the jury to try the case of State of Florida versus Jennifer Mee. This is a criminal case. Miss Mee is charged with murder in the first degree. The definitions of the elements of murder in the first degree will be explained to you later. It is your solemn responsibility to determine if the state has proved its accusation beyond a reasonable doubt against the defendant. Your verdict must be based solely on the evidence or the lack of evidence and the law. The indictment itself is not evidence, and it is not to be considered by you as any proof of guilt. It is the judge's responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of this case may be and to apply the law to those facts. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. Attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their final argument. Following the arguments by the lawyers, the court will instruct you on the law applicable to the case. After the instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the arguments of the lawyers as given by me. Until that time, you should not discuss the case among yourselves. During the course of the trial, the court may take recesses, during which you'll be permitted to separate and go about your personal affairs. During these recesses, you will not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them you're on the jury trying the case and ask them to stop. If they persist, leave them at once and immediately report the matter to the bailiff, who will advise me. This case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. If you would like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and a pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. A couple points about the notes. If you want to take them, take them. If you don't, that's fine too. It's a fairly new thing in the court system. do me this favor, because we recycle the old pads, just write your name on the top piece of paper. So not the cardboard part of the pad, but the top piece of paper. And if you do that, then every time we take a break, you just get up, flip the pad over on your chair so the bottom is up, put your pen down, you'll walk back to the jury room, and we'll leave them there. And then in the evening, we collect them all and keep them safe, and nobody gets to read them. When the trial is done, the deputies give the notes to me. I make sure they're destroyed. Nobody reads them. Another important thing, I don't know about when you were in school, but when I was in school 100 years ago, sometimes there were a couple good note takers and everybody'd want to copy their notes before a test. Well, that's not what we want. If we wanted one good note taker for a jury, that's what we'd have. So if your memory varies from somebody else's notes, you're to rely on your own memory and not someone else's notes. Everybody understand that? Okay. Thank you again for your patience. You've been wonderful. All right, Mr. Labruzzo, you may give your opening statement at this time.
She set everything up. She set everything up. On the night of October the 23rd, 2010, in the city of St. Petersburg, Jennifer Mee, along with an individual named LaRon Rayford and another man named Lamont Newton, planned a robbery. They planned to lure a man named Shannon Griffin from his apartment down on Martin Luther King Avenue South. They lured him to this neighborhood in the city of St. Petersburg with the promise of selling him marijuana, about a half ounce of weed. You'll learn that she used a social networking site known as Moco Space, M-O-C-O, to bring him to this area, and that she uses a phone to contact him and bring him there. And you'll hear that he arrives there on his little scooter, parks it at a neighborhood right next to a park. And you're going to hear that, and then there's an abandoned house. Abandoned really is for sale, but no one's living in it. And there's a dark alley behind it. And you're going to hear that the individuals, LaRon Rayford and Lamont Newton and Jennifer Mee, plan to sell marijuana back there. What we're also going to learn is that there was, in fact, no marijuana to be sold. In fact, instead of marijuana, they had a loaded .38 special handgun with 6 shots in it. And they used this weapon to force property from him. You hear that he was missing his keys and his wallet. And you're going to hear that there was a struggle over the gun. And the two individuals, the two males, LaRon Rayford and Lamont Newton, struggled with Mr. Griffin. And as a result of that struggle, they shot him 4 times. 4 times in the chest. And they left him for dead in a dark alleyway. They fled that scene in such a hurry, they left other property there. In fact, you'll get to see that they left the firearm located right there next to the body. And then they left other clothing items and shoes as they ran back to their apartment, which is located just across the street. You're going to see pictures of that alleyway, and you're going to see the things as they were left as they fled that area. And you're going to get to see the pictures of Mr. Shannon Griffin as he laid there in that dark alleyway. With no money, no wallet, and his pockets pulled out as if someone had gone through his pockets and taken his property. Ladies and gentlemen, you're going to get to hear from a person that lives in the neighborhood, a guy named Mr. John Brazelton. Mr. Brazelton's going to tell you that he was walking a dog that night. He saw that there was someone who he thought was sleeping in this dark alleyway, and that he alerts the police. And then you're going to hear how officers with the city of St. Petersburg came to that alleyway to see what was going on, if there was, in fact, a homeless man sleeping back there. Officer Bradshaw is going to tell you that as he walked up to the scene, he could tell this was something more than a homeless man just sleeping in a dark alleyway. Clothes strewn about the place, a firearm there, and an individual shot 4 times in the chest, dead on arrival. Ladies and gentlemen, you're going to get to hear about the investigation that led police ultimately to an apartment on 89th Avenue North in St. Petersburg. You're going to hear that as the police officers went to this apartment, and as they approached, they ran into 2 individuals. Miss Jennifer Mee and another female named Jennifer Sharon. They're located outside of the apartment, well, still wanting to know what was inside this apartment on 89th Avenue. law enforcement, they go and they make contact with two individuals that were located inside of it. The same individual I previously mentioned. A guy named Laron Rayford and Lamont Newton. You're going to learn that that was the apartment that all four of these individuals stayed in that night, leading into the early morning hours of this next day. And you're going to learn that the property of Mr. Griffin, the stuff that they took from him when they emptied his pockets, his wallet, his cell phone, his ID, his work ID, were located in that apartment. But not only were they located inside the apartment, they had been conveniently wrapped in a paper bag, plastic bag and concealed in the attic space, over in a bathroom, under a bathroom fan. You're going to hear how forensic techs came and they collected that, much like they collected all the other evidence in this case. And you're going to hear that when they collected the wallet, they fingerprinted this item amongst other items, and they were able to develop a fingerprint that was ultimately identified to Ms. Jennifer Mee on the Florida driver's license of Shannon Griffin. Ladies and gentlemen, you're going to hear that initially law enforcement wasn't 100% sure what Ms. Mee's involvement in this case was. She was located outside the apartment. You can hear that she voluntarily went down to the police station and that she met with law enforcement. She gave a statement. You're going to hear from a detective, Gary Gibson, and he's going to tell you that he had a chance to briefly interview her. It's a recorded statement. You're going to get to hear it. And you're going to hear how he just generally asks her what happened, what are the facts of this case. And you're going to hear how she gives a statement about that there was a love triangle or a problem between Mr. Laron Rayford and Mr. Shannon Griffin and his girlfriend, Jennifer Sharon. Well, law enforcement then continue their investigation. They take her statement, and then as more statements come out, they go back and they then read her rights, and they advise her of all those things which we refer to as the Miranda rights, and she agrees to speak with police. And again, this is recorded, and you'll get a chance to hear this. And you're going to hear now being pressed on some of the facts as to what the facts of this case are. You're going to hear how Ms. Mee explains to you just what I explained to you. That in fact, she set it up, and that there was going to be this robbery, and they were going to sell with the promise of selling him some marijuana, but in fact had no marijuana. And that there was a struggle over the gun, and the individual fought back, something they probably didn't plan on in the robbery. And you're going to hear that she acknowledges to the law enforcement she was involved, and that she set this all up. Well, ladies and gentlemen, you're also going to hear that, based on her statements and based on the physical evidence in this case, that she was arrested, and ultimately she was brought down to the Pinellas County Jail. She was placed in the booking area, as most people are when they come into the booking. You're going to hear that she made a phone call. She made a phone call to her mother. Tells her mother that she'd been arrested for murder in the first degree. And when her mother asked her, well, what happened? She's going to tell you through that call, just like she told her mom and just like she told the detectives in this case, that she set everything up. Ladies and gentlemen, we're going to ask that you listen to the evidence in this case. There's going to be a lot of evidence that we're going to present to you, both physical evidence and testimonial evidence. We're going to present to you the items that were found at the scene, the things that I talked about, the gun, the shoes, and items that were found there at the scene. You're going to hear at great length about some DNA. There's a witness that's going to be presented to you. She's a forensic analyst with the Pinellas County Forensic Laboratory. She's going to present to you evidence about DNA and where DNA was found and how it was developed there. You're going to hear that consistent with the statements that were given, that Mr. Rayford's DNA was found on the hammer of the gun, and that his DNA consistent with Mr. Rayford was found on the shell casings. And you're going to hear from other experts in this case that as it relates to this gun, that the projectiles, 3 of them that were removed from the body of Mr. Griffin, they were matched to that gun that was found on the scene. A gun that Ms. Mee identifies as being the gun that Mr. Rayford had. Ladies and gentlemen, you're also going to see the items, the wallet, and the photographs from the apartment for which they were staying in, the one that which her fingerprints were found on. You're going to hear about the interviews I told you about. You're going to hear the first interview, you're going to hear the second interview, and more importantly, you're going to hear this jail call that's going to confirm for you that she, in fact, set this all up. Ladies and gentlemen, I ask that you listen to the evidence, both the physical evidence and the testimonial evidence in this case, and when you're done, that you return a true verdict in this case. And that is a verdict of guilty in the first degree for murder in the first degree. At the end of this case, the judge is going to instruct on the law as to what is murder in the first degree. And we've kind of alluded a little bit about it yesterday, but the court's going to instruct you on it, that there are two ways to prove murder in the first degree in the state of Florida. One is a premeditated, and again, that is not the case that's in front of you. The case that's in front of you is one of felony murder, and the court's going to instruct you on the law, but basically what it's going to say is that there are certain crimes in the state of Florida by design, by enumeration by the legislature, that if you engage in such acts, such as a robbery, that if someone is murdered or killed in the course of that robbery, then you are in fact guilty of murder in the first degree. Now, as I told you, there are three individuals involved in this case. I told you that there's an individual named LaRon Rayford, an individual named Lamont Newton, and Jennifer Mee. And in this case, they have been charged as principals. And the court is going to instruct you as to what it means to be a principal to a crime. To suffice it to say, the court's going to instruct you that to be a principal in a crime, you have to have an intent that that crime be committed, an intent that the robbery be committed, and that you do some sort of act in furtherance of that crime. And in this case, the evidence is going to suggest to you that she did have an intent that that crime be committed. In fact, in her own words, she set everything up. And that she did act in this case, as she will tell you, that she contacted this individual and she brought him to that area. Ladies and gentlemen, that is the case that the state of Florida is going to present to you. At the conclusion of this case, we're going to ask you to return a verdict of guilty, verdict for guilty for planning a robbery, and in the course of that robbery, the murder of non-guilty. Thank you.
Thank you, Mr. Labruzzo. Mr. Trevina, did you wish to give an opening at this time?
Yes, Your Honor.
All right, you may proceed, sir.
Thank you, Your Honor. Good afternoon by about 2 minutes, ladies and gentlemen. Well, as the judge said before opening statements began, what I say and what Mr. Labruzzo says is not evidence in this case. The purpose of an opening statement is to kind of give you a roadmap or a guideline of where we believe the evidence will lead you. Notice it's called opening statement, not opening argument. So it's not a time to have any thunderous, aggressive arguments to present to you. And when you listen to the opening statement, listen with the understanding that this is meant to give you some cues to listen to the testimony that's about to come later and to evaluate that testimony in light of some of the issues that we're going to discuss. Now, Miss Mee sits alone as the only one charged here with first-degree murder. The state must prove to you that she committed first-degree murder, not that some other defendant who's not in this courtroom committed murder, that she is the responsible party for first-degree murder. And the state also told you that there were 3 individuals involved. They indicated that there was our client Jennifer Mee, that there was LaRon Rayford, was another name, Lamont Newton is the 3rd person, but there really were 4 people involved. We believe the evidence will show that there's a 4th individual named Jennifer Sharon. And Jennifer Sharon, you will learn, was never charged with any crime whatsoever relating to this shooting. Nothing. We believe the evidence will show that there is no distinction, evidentiary, factually, between Miss Mee and Miss Sharon, In fact, we believe the evidence will show that Ms. Sharon was likely the participant who have aided Mr. Newton and Mr. Rayford, not Miss Me, but the police, in their eagerness to obtain arrests for this crime, had Miss Me already in custody within about a 24 to 36-hour time period after the shooting. So let's talk a little bit more about Miss Me. You will learn that Miss Me is the youngest of the group of four. She was 19 years old at the time that this occurred. This, of course, was 3 years ago, come October. The shooting occurred on October 23rd of 2010. So very close to 3 years we're talking about. Miss Me is known, as you heard from the jury selection and from the court, as the Hiccup girl. Miss Me was, at the age of 15, subject to an extraordinary amount of both local and national publicity because of a medical condition which caused her to have continuous hiccups. Now you notice as she sits here today, it's unlikely you will see any episodes of hiccups because she is now controlling that condition through medication, including Thorazine. But when she was 15, this was a young girl, a high school student at the time, who...
Judge, I'm going to object if we could approach for a moment.
Uh-huh.
So Miss Me had been the subject of a lot of attention then. By age 19 now, Miss Me finds herself in an apartment, sharing that apartment with herself and a male friend, Mr. Lamont Newton, and Mr. Laron Rayford and Jennifer Sharon, like two couples rooming together in an apartment in St. Petersburg. So they were residing together. Now, Miss Me received income.
Judge, I'm objecting.
Approach the bench.
So suffice to say that Miss Me had resources, had money. Jennifer Sharon, you will hear, she's going to testify that she had considerable amount of money, that she was making good money. You will learn through the testimony and cross-examination that she was working essentially as a prostitute, making money. The other two gentlemen, not any evidence to show that they had really any money or any sources of money. So you have this situation where Miss Me, 19 years of age, in this apartment, 3 other individuals all sharing this small apartment, and there is some discussion about meeting up with someone, and this is where the story diverges in many different directions, because you're going to hear that each of the witnesses, each of these individuals gave differing statements. They told different stories. And you'll hear from Jennifer Sharon that after the shooting of the victim in this case, Mr. Griffin, that there was an attempt to sit down and develop a cover story or a strategy that each of them would memorize, that each of them would rehearse, in an effort to try to place the most blame on the individual who they thought would be the least likely to suffer the worst consequences for what had happened. So there was an active attempt by these individuals to collaborate and come up with a story that they could sell on the police that would minimize the involvement of certain individuals and kind of maximize the involvement to others. One of the things that came out, one story that we suggest the evidence will show bears the most forensic support, because science is going to be a big part of this case for you. When you go back and eventually deliberate after hearing all the state witnesses in this case and hearing all the evidence and testimony, you have to consider what scientific evidence corroborates the verbal testimony of different witnesses. It's extremely important when you already know beforehand that there has been adjustments to their testimony, adjustments to how this supposedly occurred by each of these people. One of the statements that was touched upon briefly by the state in the opening dealt with a love triangle. Remember, Mr. Rayford was in a relationship with Jennifer Sharon. The one statement, one that was told by my client, Miss Me, and one that had at one time been told by others, was that Mr. Rayford became aware that Jennifer Sharon had been texting the victim, had been communicating with the victim on social media, and you'll hear the term Moco Space, which is a social media site that was referenced by these individuals. It's important to note and listen carefully during the testimony as to who possessed and who owned the cell phones that were used for communications with the victim. Very important. No computers involved. You won't hear any testimony that any of the individuals utilized a laptop or a PC to effectuate these communications. These were communications that were done through like a smartphone. It will be proven to you unequivocally that Miss Me did not own a cell phone. But the state will attempt to attribute certain text messages, certain communications to Miss Me, despite the fact she didn't own the phone, and that Miss Sharon and Mr. Rayford, you will learn through the testimony, really had primary access to the phone. You will also hear that Mr. Rayford was the one who actually had the phone in his name. And he didn't have only one phone. We know of at least 2 phones, possibly up to 4 phones. 2 were identified through forensics as being registered or owned by Mr. Rayford. There was a 3rd track phone that had no owner identification, the type that you would like pick up at Walmart or Target, those types of phones. So there's not going to be any evidence presented to you that would show that would prove to you beyond a reasonable doubt that Miss Me even had any of these communications with the victim. You will hear testimony how Ms. Sharon claims, because now she essentially becomes the star witness for the state. She's not charged with any crime. She's told, you're not going to be charged with any crime. She's the first one when she is approached by law enforcement who says, I want a lawyer, I don't want to talk to you. The first one, the only one that lawyers up. And the police say, we're not looking at you as a target. We're not looking at you as a defendant or a suspect. We're looking at you as a witness. Tell us what happened. So then she tells the story of the romantic triangle where LaRon had followed her, apparently in her attempt to meet Mr. Griffin, that when he saw Mr. Griffin and Ms. Sharon together, he exploded, became enraged, pulled a pistol, and no one's ever going to claim that Miss Me ever had a pistol, possessed a pistol, fired a pistol, had anything to do with a pistol. Mr. LaRon Rayford had that gun, and Ms. Sharon will tell you that after he saw the 2 of them together, he shot the victim. He pulled him around in the back of the alley and he shot him 4 times. Remember, as you listen to the testimony, the number of shots. The second story, which the police try to adopt as what really happened, says that this was supposed to be a marijuana deal that went bad and that there was a scuffle over the gun between Mr. Rayford, Mr. Newton, and Mr. Griffin, who is deceased. And during that struggle over the gun went off and he was killed. No one really intended to go shoot him. It was just during the struggle with the gun. Ask yourself if that version makes sense to you when you listen to the testimony, because we're going to suggest the evidence will show that doesn't add up. 4 shots takes quite amount of thought and dexterity to crank off 4 rounds from a revolver. And you'll learn that this was a revolver-type gun. That seems to be indicative of more of a crime of passion, which tends to lean towards the first story. But the police didn't want to accept the first version. They kept pressing and pressing and said, no, there's got to be more to this. We want to know, how is Miss Me involved in this? So the story shifts, and then Miss Me is, according to the police, accompanies LaRon Rayford and accompanies Lamont Newton to this vacant home, and that an introduction is made. Miss Me is leaving the scene, and that in the interaction between Lamont Newton and LaRon Rayford and Mr. Griffin, the victim, he ends up being shot 4 times. The gun was actually discharged, you'll hear from the police, 6 times. It was emptied. So again, as the judge said at the beginning, don't check your common sense at the door. You are now the judges and the detectives of the facts of the case. Apply your life experience, your common sense, your logical reasoning to what really makes sense in this case. 6 rounds fired, 4 hit him in the chest. Even according to the police version, Miss Me is gone. By the time the gun is fired, she is not at that scene. But they want you to convict her now, the state, of murder in the first degree, the most serious offense which a person can be charged, based upon their theory that Miss Me was helping set up a marijuana deal that somehow went bad, and that during that marijuana deal that went bad, Mr. Griffin was shot, and therefore she should be as equally, according to them, as equally culpable as a person who pumps 4 rounds into someone's chest. That's the state's theory. Now, I believe the judge already told you, and you heard during jury selection, that the fact that a grand jury issued an indictment does not mean that Miss Me is guilty of any crime. It's not evidence that you can use against her in any way. So none of you should think, well, you know, this was heard by a grand jury, they issued an indictment. The prosecution goes in and obtains an indictment without the participation of the defense. So that's kind of a one-sided issue. And that's why the law is you're not to consider that. What you are to consider, and what you must consider, is the testimony of the witnesses that you hear from the witness stand, exhibits that may be entered into evidence, such as photographs, the gun, whatever the state elects to place into evidence before you, and to the law that the judge instructs you, and that packet that you will get at the end of the trial. Those are the things that you will limit yourself to. Now, there is some physical evidence in this case, and all of you should take careful note of what that physical evidence is. Some of it's been mentioned by the state. There was DNA found on the gun, DNA found on the shell casings that went into the revolver, and that DNA came back to LaRon Rayford. No surprise there. He's a gentleman who pulled the trigger and pumped 4 rounds into this man's chest. Something that the detectives, when they testify, and the state hasn't mentioned yet, that it was, I believe, to be crucially important in your assessment of the evidence, ask you to listen carefully. Found at the crime scene is a condom wrapper, opened, a condom, and the victim is found with his pants pulled down, far down. And you'll probably see a photograph of that. Unzipped, unbuttoned, pants pulled down. You'll hear the detectives say, because they've been asked this question during the course of the discovery in this case, they will testify that they didn't even know or think that that was even relevant to this crime. See, that might have been some trash in the alley, probably had nothing to do with this case. Well, one of the big points in this case is the left hand didn't know what the right hand was doing. Well, one detective is saying it's probably not even related to the case. Another detective is submitting that for DNA and fingerprint analysis, and guess what? It comes back. And again, we have LaRon Rayford as being the one who handled that condom. Now, how interesting is that? The first version says love triangle, sex, intimacy, romantic encounter. State wants you to disregard that theory. They want you to believe Miss Me set up a marijuana deal that went bad, and this gentleman ended up shot for that reason. Well, who brings a condom to a marijuana deal? So listen carefully to that testimony. Mr. Labruzzo made a point of talking about that there were certain items of property of the victim that was found hidden in the residence. Wallet, cell phone ID, that my client's fingerprint was on the driver's license of the victim. Does that prove that she killed someone? Does that prove that she set someone up to be killed? Of course not. It just means that at some point that was handled by Miss Me. And it may have been something as curious as just to see who it was that was shot. You notice Jennifer Sharon, their star witness who was never charged with anything, she's going to admit to you that she participated in hiding things. She's going to admit to you that she participated in cleaning up, bleaching clothes, doing everything she could, moving the parties around, relocating them to protect them. She wants you to believe that she wasn't even at the crime scene at all, and that she did all of this out of the goodness of her heart. She did all these acts that are entirely illegal and known as accessory after the fact. An offense very severe in Florida. No charges. No deals. It wasn't like it was a deal cut. It wasn't like the detective said, Ms. Sharon, you tell us what really happened, and we're not going to charge you with a crime. It was the detective saying, Ms. Sharon, tell us how Miss Me's involved, and then you won't be charged with anything. You're a witness. You're not a defendant. Well, why are they so interested in Miss Me? Why are they so interested? They're interested enough to have a press release immediately after her arrest and announce to the world and splash on every front page across the country that the Hiccup girl was arrested for murder. What's in a more appealing case to a law enforcement agency?
I'm checking it's argumentative at this point.
Sustained. Move on.
Will do, Your Honor. In closing, I'm going to say, again, common sense will lead you to the right decision in this case. You heard it in the beginning, you'll hear it again. This table does not have to prove or disprove anything. And that's a fundamental constitutional right that all of us, each and every one of us have. She's not required to say anything. Theoretically, we could sit mute throughout the trial, and it doesn't change the burden of this table. The state and the state alone must prove to you each and every element of first-degree murder beyond a reasonable doubt. And if they fail to do that, there's only one possible outcome, and that is not guilty. And you may leave after the trial and think, I wonder what really happened. I wonder what this was about. All that shows you is that they have failed in their quest to provide those answers to you. If I may have a moment, Your Honor.
Yes.
I have nothing further. Thank you.
Thank you. Okay, ladies and gentlemen, I'd hope we'd be further along than we are, but it's 12:35 and the cafeteria quits serving some things at 1, so I'm going to go ahead and let you have your lunch break in just a moment. Please leave your pads and pens. Like I said, flip them over. Please do not go online for any reason. Please do not, I mean, you can check your personal email if you have it, but don't look at any news, local, national. Don't read the newspaper. If there's a TV on, don't look at it in the building. Please try to avoid anybody else that's having any conversations about this case, and I'm going to talk to the people in the courtroom about that when we leave here too. So thank you very much for being on time. I promise we will move along at a much better rate this afternoon. Without mentioning your name, were you able to schedule an appointment for tonight? Okay, so does anybody have, and I don't need you to put your name out there or anything, but any kind of commitment tonight that would make a difference about how long we go? Okay, all right, thank you. Remember, don't discuss the case among yourselves or with anyone else. Thank you. It's 25 minutes to 1. We'll see you at 25 minutes to 2 in judicial reception. If everybody could just hang on here for a minute, I'd appreciate it. About this down in the cafeteria or in the halls or anything. As you can see, we've worked really hard to get where we are, and we would like the jurors to just be free from hearing anything or creating any problems. So everybody's been real professional about that, and I appreciate it. I'm not being critical. I'm just saying please pay that extra attention, because I know even in my own case, as long as I've done this, there's times I just have to remind myself of that. So thank you very much for your cooperation. A couple other things that have come up about from the deputies. We need to make sure, I see your first witness is out there. I know you'll get to him in a minute. Let's not have any personnel but lawyers in front of the bar here. So your office people, there have been a bunch of people coming and going, so just, you know, they can be right behind the bar. You can talk to them. Any lawyers that need to leave the courtroom to talk to somebody, you got 3 lawyers, you got 2 lawyers, so the lawyers can move around the courtroom as you need to. You can leave the courtroom so long as there's somebody here that's responsible. If somebody has an emergency, they need me to take a break, I'll be happy to accommodate that. I'm not trying to inconvenience anybody, but we got so much going on in this trial, and I'm trying to make the bailiff's job as easy as it can be. Okay, And extra care just to keep the witnesses away from the jurors. And so is the rule invoked, anybody? Nobody's asked me that, have they? I don't care, I'm just asking,
I
so
would
we're clear.
request it, Judge.
Okay, all right. So state if you'd advise your witnesses, and of course that applies to the defense's side too. All right, anything else, state?
No, Judge.
Anything else, defense?
No, Your Honor.
All right, we'll see you at 25 minutes till 2. Thank you.
All right, court is in recess till 25 minutes till 2 according to the courtroom clock.
Yeah. Some bananas.